Well, good afternoon, everybody. My name is Dulcie O'Sullivan. I work for the Department of Construction and Inspections, and I lead a program called Renting in Seattle, which is basically the outward-facing access for folks who need information or guidance on rental regulations in Seattle. And I will be referring to our Renting in Seattle website. I'll be putting some links in the chat to that throughout the presentation. I'm joined today by my colleague, Maureen Rote, and she manages the Property Owner and Tenant Assistance Unit for the Department of Construction and Inspections. And today we just put together a very basic PowerPoint, just as a sort of starting point, based on what we've been getting calls about the most from landlords predominantly. The information is useful for anybody who's either renting or who's a landlord. But since the burden is on the landlord to know the rules, this information is probably more useful for landlords who are joining us today. So we're going to get started. We can go to the first slide. This is an overview of what we're going to just sort of speak to. If you have questions, you can put them in the chat, please, and I will answer them in the order they're received or in the order of relevance as they relate to the PowerPoint. Other things I should mention, and I might have to say this a couple of times, is that we are well aware there is frustration in the landlord community about the burden that's been placed in terms of the eviction moratorium. I'm a small landlord myself, so I understand that perspective. But just to remind people that neither Maureen nor I create the legislation. We don't pass the legislation. We have no control over it. We're merely humble civil servants who are here to help people understand what it is that is required. So if you do have strong feelings about the legislation that's been passed lately, I would encourage you to take that to your council members or your elected mayor, and that would be far better received in terms of what they can do in response than anything that we can say or do. So just to put that out there, we had a home fair yesterday, and that was something that did come up. So I am going to just hand you over to Maureen for a few housekeeping things, and then we'll get started on the PowerPoint. Thank you for your patience.
Okay, thank you, Dulcie, and good afternoon, everybody. I just wanted to put out a few administrative things while we're going through the slides and questions and answers. You should have all gotten a notification when you logged in that this is being recorded. So we're recording it for posting on the website for people who are unable to join us today. So keep that in mind. Please remember to remain muted when you're not speaking. For the most part, we will be taking questions through the chat function. And if you are submitting questions through the Q&A and not getting an answer, that's because we can't see it. So please make sure you're in the chat function rather than the Q&A function. There is an option for closed captioning. If you need closed captioning assistance, you can utilize that. And there is also an option for translated versions of the program using the closed caption option. Okay. So we look forward to talking with you all today, and I will throw it back to Dulcie.
Thanks, Maureen. And I should also say that even though we did put together some talking points for today, really this opportunity is to provide access, meaningful access to the public, to the department. And so we're happy to answer questions or discuss anything rent related once we've gotten through the presentation. And there should be some time for that. There was yesterday. Okay, so an overview of what we've prepared today. We're going to discuss eviction in Seattle in general. We're going to discuss right of first refusal, which is a fairly new ordinance, right to counsel, the new rent increase law, some guidance and best practices around issuing or receiving notices. And then we're going to just touch on the economic displacement relocation assistance ordinance, which goes into effect in July of this year. So it's not in effect yet, but we are in the process of building that program. So first, we're going to talk about eviction because that is the number one thing that we're getting calls about. So let's go to the first slide. So currently, the COVID-19 eviction moratorium has been extended by Mayor Harrell until February 14th. And what that means is that evictions are only permitted where a tenant is posing an imminent threat to health or safety. So that is the only reason currently a landlord can take a tenant to court to try and evict them. We don't know if that date will be extended. We know that the mayor is asking departments for information and feedback on the status quo to make some decisions, but we honestly have no idea if it will be extended again or if it will expire on February 14th. What we do know is that once the COVID-19 eviction moratorium ends, we do have some new laws that will come into effect. And so we describe them as defenses to eviction. The first one is COVID-19 related inability to pay. So anyone who has delinquent rent that was accrued between March 2020, which was the beginning of the emergency order in the city, and the eviction moratorium, up to 6 months after either the end of the moratorium or the end of the emergency order for the city. There are some other protections in there regarding late fees and costs of eviction. But that's basically the defense, is that the person cannot afford or is behind on their rent because of the pandemic and the impacts. The second eviction moratorium is the school term moratorium, and this limits evictions for households with students. So anybody that's in childcare, could be preschool or daycare, all the way up to high school, and also any employees of schools during the school term. So it's a fairly broadly applicable ordinance, and the length of the moratorium will depend on Seattle School District calendar, which is why I have September 1st through June. Typically, it's around June 15th, 17th, something like that, but it's slightly different every year. But that means that now there is a defense to eviction that will limit households with children or students or employees of schools during that period from September to June. And then we also have the winter moratorium, and this limits evictions of moderate to low income households during the coldest weather months, and that would be December 1st to March 1st. We can go to the next slide. So these are some exemptions to some of the moratoriums. The landlords with ownership in 4 rentals or less, the winter moratorium does not apply. However, it does apply to the school term moratorium. Can we just go back? We're not ready yet. Thanks, Maureen. So some of the exemptions that apply to the winter moratorium and the school term moratorium is if the landlord seeks to occupy the unit for themselves or an immediate family member. Family member is defined in code, and that requires a 90-day notice. And of course, again, just to reiterate that this will happen once the COVID-19 eviction moratorium is expired. If the property is a single family dwelling unit, then it's a 90-day notice. That's also exempt. If a landlord has to discontinue renting an illegal unit because they've received a notice of violation, a land use notice of violation from the city, that would also be exempt. It does require relocation assistance payable by the landlord. And if the tenant is on a month-to-month rental agreement, the typical notice time would be 20 days. If they are in a lease for a specific term, then that needs to be negotiated. So we can go to the next slide. Other exemptions would be to reduce the number of renters, again, after receiving a notice of violation for exceeding the maximum allowed in a single family dwelling unit. That also requires relocation assistance. If the unit has been ordered to be vacated and closed because of an emergency condition, that would require relocation assistance, and that is also exempt. If the landlord wants to discontinue sharing their own home or ADU on their property, that's 20-day notice. To terminate a tenancy for illegal or criminal activity, that's a 3-day notice, which must be sent at the same time that you serve it timely to SDCI so that we can check for compliance, and we also are required to record it by code. So it's important, if you're issuing that kind of notice, that you make sure you send a copy at the same time to the department. And finally, to terminate a tenancy for conduct that poses a serious and imminent threat to health and safety. So that currently is the only reason you can evict somebody in Seattle under the COVID-19 eviction moratorium, and it will always apply for in any situation once that moratorium is finished. We can go to the next slide, please. So one of the things that we should comment on is that eviction in Seattle, just cause eviction, was sort of the gold standard in Washington state for protecting tenancies from arbitrary termination. And over the last few years, other municipalities have adopted it, and now the state has actually adopted a just cause eviction ordinance, which means that a landlord has to have a good cause in order to not rent to somebody. And so what this means for the city's just cause bill is that now the just cause eviction ordinance applies to all rental agreements in the city, not just month-to-month agreements. The landlord has to have one of 16 just causes to terminate a tenancy. And like I said, the ordinance applies to all tenancies, rental agreements, and leases. So before I go on to the right of first refusal, I'm just going to check and see what questions we have here in the chat and see. So Captain says, does Seattle rental laws apply to properties outside the city limits like Newcastle? No. Anything we discussed today is strictly applicable to the city of Seattle and within Seattle city limits. Maureen actually spoke to that. I'm sorry, Maureen, I didn't see that. A serious and imminent threat. So we get asked that a lot because it's the only cause that a landlord can rely on currently and for the last couple of years to evict somebody. I mean, I would say that it's usually pretty clear when there's an imminent threat to health or safety. It's usually a pretty clear line. And if you're having to ask, is this an imminent threat to health or safety? Then it probably isn't. It's pretty obvious when a tenant is posing a hazard to themselves, to the unit, to the landlord, or to other people in the building. The behavior will show that very clearly, and it should be very clear and obvious and imminent if you're going to rely on it to evict somebody on a 3-day notice. So that's all I can really say. Whenever we look at these things, we look at what a reasonable person standard would be. And so whatever a reasonable person would say felt threatening or was imminently dangerous is the standard we would look at. And we would look at the evidence to support that, as would a commissioner or an attorney. So basically, that's what I have to say about imminent hazard. Somebody's asking if this is going to be recorded. It is being recorded. Ryan R is asking, what is maximum rent or occupancy? I thought in a previous session at the housing fair this weekend, I heard that there are new rules. So we did discuss this a little bit yesterday. There is a just cause that applies to single family houses with 8 or more unrelated people. That is not the same as the roommate bill, which is a separate thing. And we can talk about the roommate bill a little bit later if that's something that people want to talk about. But basically, it's very rare that this just cause comes across our enforcement books. From my history of enforcement, it generally happened in rooming houses where people were renting single room occupancy type units, and there would be more than 8 units in a single family dwelling unit, which is defined in code as well as a specific type of structure. So that's what that refers to. That's the question somebody was asking. And there are occupancy limits, but they aren't clear, very clear, in terms of trying to say this many people can fit into this many square feet. Again, that's a little bit of a digression, so we can talk about that a bit later if it's something that people need some clarification on. Let's see, anything else here? We have Vin, who's saying, so 16 just causes now applicable to 1-year lease. Yeah, all these causes apply to every type of lease agreement in Seattle. You basically have to have a reason in order to not renew a tenancy or in order to terminate one. And it has to be one of those 16 just causes. Okay, so somebody's talking more about the roommate law. Let's come back to that later. But I think I've caught up with most of the questions that I can see that were in the chat. So right of first refusal, this is a fairly new rule as well, and it basically makes the difference between a landlord being able to use a lease to displace somebody versus a just cause. So now, since you have to have a good cause, if you rent it to somebody and they're in good standing, you're required to make a reasonable renewal offer between 60 and 90 days prior to the expiration of the tenancy. Or if you're not prepared to do that, then you'll have to give them a notice declining to offer that renewal and stating that just cause and the supporting facts. The tenant has 30 days to accept or decline the proposed rental agreement. If the landlord's lease is set up to automatically convert to a month-to-month agreement, then there is no requirement to offer that renewal because the tenant is guaranteed the continuation of the rental if it's automatically reverting to a month-to-month agreement. And if the tenant actually gives notice to vacate 60 days prior to the expiration of the rental agreement, there is no requirement to offer the lease renewal either. Let's see here. Is just cause the same as eviction? Okay, so it's kind of one of those things. These words are sometimes meaning very specific things, and then also they can be interchangeable. So it's a bit confusing. So eviction, I would say, is the physical removal of somebody from the property. It's when somebody loses the right to possess the property. That's eviction. But people use eviction in a very general sense. You can only be evicted through a court action, but you can have a termination of tenancy also. That does not necessarily require a court action. So, for example, Maureen is my tenant. She has been, let's just say, she's been late with the rent 4 more times in the first 6 months of her lease agreement. That gives me the just cause to decline to renew her lease because it is habitual failure to pay rent on time. So I would issue a notice of termination to Maureen and I'm declining to offer you a renewal of this tenancy because you've habitually failed to pay the rent on time and I have had to give you 4 or more 3-day notices, or excuse me, 14-day notices, 14-day notices in the most recent lease period. If Maureen decided that she did not want to actually move out pursuant to my termination notice, then I would have to take her to court to get her evicted. So if you kind of think about it like that eviction is generally or specifically when you have to go to court to remove somebody's right to be on the property. A termination of tenancy doesn't necessarily have to end up in eviction court. And an unlawful detainer is the lawsuit that a landlord has to file when they want to evict a tenant. Maureen, do you have any other pearls of wisdom? I'm sure you do, about trying to make it clear for people about between eviction and termination.
Yeah, I mean, we definitely throw a lot of terminology around related to eviction, termination, and just cause. But if you think of it as just cause is the precursor, you need just cause in the city of Seattle to move to the eviction process, which is the legal process for removing the tenant. And then if you have just cause and you issue a notice in normal times, right, we're a little bit in a strange time with the eviction moratorium and COVID, but in normal times, if you issue a notice under the just cause eviction ordinance and the tenant doesn't comply or the tenant doesn't vacate, depending on what type of notice it is, then the next step is to move into that court process that Dulcie was talking about. And the court process is really what results in the eviction, the removal of the tenant by the sheriff. That is something that has to be done through the courts. It's not something that can be done through self-help or other means.
Right. And in fact, if you try and do that, if you try and change the locks or put a tenant's stuff outside or skip any of the proper legal procedure, it can be a criminal charge. It can result in criminal charges. So it's definitely not something you ever want to do. Okay, so I don't see any other questions on right of first refusal for now. So let's go to the next slide.
Well, I'm going to take us back just a second, Dulcie. We had a question come in about just cause eviction.
Mhm.
So it's, let's see who this is from. This is also from Vin. Why in just cause eviction related to the owner wanting to sell does it not apply to townhomes? In other words, I rent my townhouse today at well below market. The tenants wouldn't want to move, but I sell and now have no way to sell it. So that's a bit of a misnomer that you wouldn't have a way to sell it. You would be able to sell the property with the tenants in it, which a lot of people don't realize. They think, you know, wow, if I have tenants, I guess I'm just stuck and I can't move this property onto the market. You can sell with the tenants residing in it. And the reason for just cause excluding certain types of housing is because it's limited to single family dwellings. And single family dwellings in Seattle are very specifically defined. They are essentially detached from other units, from other properties. So that's the reason why condos, townhouses, and duplexes can be excluded from that just cause. If you have another just cause, you could use that just cause to remove the tenant. You just can't issue that notice of intent to sell as a way to get them out.
And the other thing to note is negotiation can often work. I mean, usually if there's a good relationship, a landlord and a tenant can come to an agreement. In my experience, most tenants don't want to stay in a home that's for sale. They don't want to be bothered by the viewings. They don't want the uncertainty of when it's going to sell. Um, in my experience, they're more than happy to move once they know that the property owner wants to sell. But that's just about communication and negotiation. And yeah, single family dwelling units are detached and on their own permanent foundation. And that's why none of the other types of housing meet the definition. Okay.
Thanks. There was also a question about what if there is no written notice to vacate? This one's from Stacy. Are they bound to pay those rents for the months after they leave? That's going to depend on your lease. If you have a tenant who has vacated early, and you want to find out what you're entitled to, you might want to talk to an attorney for what your legal options might be to collect on anything that occurred after the tenant vacated if they were in a term lease and just left.
Yeah, and Stacy also says, I think there's some confusion here. So you can evict based on imminent threat, but also if there are rent disputes. Currently, no, you cannot evict for rent disputes. Currently, COVID-19 eviction moratorium is still in effect until at least February 14th. And that means the only reason you can evict somebody is if they're hazardous to health and safety, imminently hazardous to health and safety. Once the COVID-19 eviction moratorium is over, then everything will apply. But as we went through the beginning of the presentation, there are several new protections in place. And in fact, I didn't mention at the time when I was talking about these defenses to eviction, we don't even know what those will look like when they play out in court because they've never been used before because they were passed while the COVID-19 eviction moratorium is in place. So we don't know how commissioners are going to look at these defenses. We don't know what clever attorneys are going to try and do for and against them. It's all to see. It's all something that we have to wait and see what's going to happen with it. But for right now, it couldn't be any clearer. You cannot evict anybody unless they're actually a danger. Another new piece of legislation that was passed is Seattle's right to counsel. And what that means is that once a tenant receives an eviction summons and they cannot afford an attorney, they have a guaranteed right to legal representation. And the city partners with Housing Justice Project, which provides this legal counsel. They are based in King County Courthouse. They used to be just a walk-in service, but since COVID now, they do intake via the phone, via the email address that I have listed there, HJP staff, and via this online form. Now, they do not assist landlords, just to be clear. They only serve tenants. So if your tenant needs help, or if you're a tenant, or if you know a renter, this is the resource for them if they get a summons. Before the summons comes the notice. And so the notice is what the city will look at because we have jurisdiction over the just cause eviction ordinance, which means that when you write a just cause eviction notice, it has to meet certain requirements. And so when the renter receives the notice, they can contact the city, they can contact the Renting in Seattle helpline, and we will review the notice to make sure that it complies with all the regulations. Again, just to reiterate, once a summons has been served, the appropriate resource is Housing Justice Project. Okay, do you want to go to the next slide? So housing cost increases. So before in Seattle, we had two periods that applied to housing cost increases. There was the less than 10% and the more than 10%. Well, now it doesn't matter how much you raise the rent in terms of the amount of notice you need to give. All rent increases, all housing cost increases require 180 minimum days prior written notice. And that can't include the day of service. So all rent increases. No increase can take effect if the rental unit fails any of the rental registration inspection ordinance checklist requirements. These are fundamental safety issues for the most part. And if the renter receives a notice of housing cost increase and reports to the landlord that there is something in the unit that does not comply with the RIO checklist, they can also let the city know, and we will require that to be repaired or fixed or, you know, put right before the increase will go into place. You also need to be registered in order to just even issue an eviction notice to a tenant. I'm still on the previous slide. Sorry. There's required language for housing cost increases, and that I have it in bold there. It's also under landlord resources on our webpage, our website, www.seattle.gov/renting in Seattle. So this language has to be on the housing cost increase notice. If you need help understanding this notice or information about your renter rights, call the helpline or visit the website. That has to be on the rent increase notice, or the notice would be considered deficient. And if a tenant brought that to the city's attention, we would require the landlord to rescind it and have to start over with a new notice. So it's really important you pay attention to the details. Our recommendation in always when dealing with legal processes is to use legal counsel, or at the very least a landlord advocate group like Rental Housing Association or Washington Multifamily Association. So we can go to the next slide. So deficient notices can be rescinded, like I said, or cause significant delays. A deficient notice might have incorrect or missing language, lacking dates, lacking a signature, or correct wording. The devil is in the details, and technical correctness really matters when it comes to issuing notices to your tenant. For all notices that could eventuate an eviction, such as a 14-day pay or vacate, or a 3-day quit, or a 10-day comply, or a notice to terminate for just cause, the following language is required. And this is because if the tenant is going to be subject to eviction, they have this guaranteed right to counsel. So that's why these notices have to have this language. In addition to the language that we talked about before on other more sort of less significant notices, like if the landlord wants to seek access or raise the rent. But anything that says or vacate on it has to have this legal counsel language on it as well. The right to legal counsel, city law provides renters who are unable to pay for an attorney the right to free legal representation in an eviction lawsuit. So that has to be on any eviction notices. Hey, I'm just going to check the chat again. I know Stacy went back to, or somebody went back to imminent threat again. Let's see. I don't think there's anything. There's a question from Stacy. I assume the law is different in each city or each state. Yes, I mean, there are some laws in common and there are state laws that apply in all the municipalities. But when you're in Seattle, you have to use Seattle specific paperwork, which is why you really do need legal counsel if you're trying to evict a tenant. You really do need to have that legal expertise. Captain to everybody, is right to counsel available to tenants outside the Seattle city limits? Maureen, you might be able to weigh in on that. I think there is a state level right to counsel. Do you want to speak to that, Maureen? You're probably more familiar.
Yes, I can definitely do that, and I dropped it in the chat as well. The state, around the same time the city passed its right to counsel, the state also passed a right to counsel bill, which gives low-income tenants the right to an attorney at the time of the show cause hearing. So that means the time they go into court for the eviction is when they would be essentially appointed an attorney in different areas throughout the state. And that, again, that applies statewide. It's not limited to the city of Seattle. City of Seattle's right to counsel law applies a little bit earlier in the process. It applies at the service of the summons and complaint. So when that tenant receives that summons and complaint, they can go to the Housing Justice Project and get representation by an attorney there. And as Dulcie mentioned, the city is funding and partnering with Housing Justice Project for that right to counsel. That was a directive that was put through in the ordinance itself when it passed, was that funding would come from the city for those attorneys.
Right. And it's really a good thing that our ordinance is triggered earlier in the process, because sometimes tenancies can be saved, or landlords and tenants can avoid eviction court if legal counsel gets involved earlier. So it's a good thing. It's a good thing that tenants can go and get some advice or representation and try and work things out with the landlord before it goes to court. Okay.
There is another question in the chat related to rent increases. It's from Jessica. Do you need to give 180 days before you renew a lease? For example, a tenant has a 12-month lease, and at the end of the lease, I intend to increase the rent. Do I need to provide 180 days prior to the end of the lease? Yes. After the passage of the new law, if you are giving the offer of a new rent increase or a new rental agreement, and that rental agreement is going to include an increase in the rent, you have to provide 180 days notice of that rent increase.
Yeah, so it's just a hard and fast rule, 180 days for any type of housing cost increase. There's a question from Jessica also about going more into Rio. We don't really present on Rio. It is obviously something we refer to because it does have bearing on some of the application of these rental regulations. But for the most part, it's sort of its own separate program within the department. What I can tell you is that you need to register. Now I think it's every 2 years, and inspections are done once every 10 years, generally speaking. If you need more information on rental registration, there's a specific rental registration number for you to call, and they can talk you through anything that you need to know about registering your property, about the inspection process, etc. Okay, so let's go to the next slide. We're making good time here. Stacy had another question. I think your question is about notices, and you're saying templates or a lawyer. So we would strongly advise any landlord who needs to issue a notice to make sure that they're getting it from a reliable source. And again, in this particular slide, you'll see at the bottom there, I'm naming the Rental Housing Association and the Washington Multifamily Association. We have a very healthy dialogue with them, both organizations. We see that they do good work with their paperwork. And so they are reliable sources for landlords who are looking for that paperwork. They provide rental agreements, they provide notices, they provide all of the written documents that you would have to rely on in a landlord-tenant situation. Or you can go to an attorney as well. That's probably going to be a bit more expensive, but definitely needed if you're going to actually evict somebody. So that's what I would say. You don't have to go to an attorney necessarily to get proper notices, but you definitely need to go to a reliable source, and not one off the internet, and not one that's not specific to Seattle. These are very important things to know.
Yeah, I can't emphasize that point enough. My group is charged with enforcing the rental housing code as it applies to residential tenancies. That includes reviewing notices that come into our department from tenants in the form of a complaint. And when we review those notices, 9 times out of 10, the reason there's a problem with the notice is because it was pulled from the internet from another jurisdiction and doesn't have the special language requirements or the information that it's required to have in the city of Seattle. So please be really wary if you are pulling something from online. Make sure that you are, looking at reputable organizations that are putting out forms. And again, it's always advisable, particularly now with all of the changing laws, to speak with an attorney before you serve a notice.
And then also, in addition to getting the technical details right, you also have to get the service correct. And so notices, we get this question all the time. These really impactful material notices need to be written in hard copy. Some people just assume email is written. Now, if you want to follow up and also send it by email, that's okay, but it can't be your primary source of service. You're required to attempt personal service, and if that's not possible, then you have to post, you have to mail by first-class mail with a proof of mailing receipt, and also attach a copy of the notice conspicuously to the entry door of the tenant's home. And so it's one or the other. You either serve it personally to them, put it in their hands, or you have to do this posting and mailing. And you have to allow a full additional day if you're doing posting and mailing, because you need to give that extra additional time for the mail to get to where it needs to go. And like I said, reputable landlord agencies, we work with Rental Housing Association and WMFA, and we'd be confident in recommending them as good resources for landlords. Okay. We can go to the next slide. So we're at the end, pretty much. This is the last couple of slides. So this ordinance is not in effect yet. It goes into effect in July. And basically what it means is that if a tenant household receives a housing cost increase of 10% or more, either in one fell swoop of an increase, or if accumulatively over the space of 12 months, increases, which would be 2, because you'd need, within a 12-month period, you could only raise the rent twice with a 180 days notice. If accumulatively those 2 increases make up 10% in the most recent 12 months, that would also trigger this. But what it does essentially is, if a household receives a 10% or more housing cost increase that they can't afford to pay, and which results in them having to move out, they can apply for this economic displacement relocation assistance. And we can go to the next slide. And basically what that will entail is we are building a program out right now, because the tenants will be submitting their income documentation to us, and then we will review it, and we will just determine whether the household meets the income limitations, which are 80% of the, area median income. So for example, for an individual household, that would be $53,760 currently, or for a family of 4, $76,800. So pretty low threshold there for the median income. And the household either moves, or as a result of the housing cost increase, or they give notice to vacate after they've received a housing cost increase. So we will administer the program. We're currently building it. We need IT and all of that functionality. We hope that tenants will be able to apply on the website by just clicking a button. We'll have to do some outreach and so forth before this happens, so that landlords are made aware. So we will share information well before July through the listserv that we have for landlords, and we'll post information on the website as well. So essentially, eligible tenants will be eligible to receive approximately 3 months the average monthly housing costs. So 3 times the rent, sort of to make it simple. The city will advance the money to the tenants so that they don't have to wait. And then we will send notification to the landlord, and they will have 10 days to pay, to reimburse the city for that relocation assistance. I think somebody's mic is not muted because I can hear somebody talking. Can you guys check your mics and make sure you're not muted unless you want to speak? Thank you. So that's what the program will look like. There will be requirements for the landlord to issue notices to the tenants, and then there will be a requirement for the tenant to apply for relocation assistance, and there will be timelines and everything, but we're just working that out now. But like I said, prior to July, we'll be sharing information about this new bill. But that's essentially what it is. Anybody that's going to be displaced by a rent increase of 10% or more, and they meet those income thresholds, will be able to apply for relocation assistance. I think that was the last slide. I think we might be on questions now.
Yeah, and it's good timing. We do have a question in the chat about economic displacement relocation assistance from Ryan. Will the landlord be notified of the application at the time of the application? Yes, the city, as part of the requirement in the code, will notify the landlord when we've received an application for assistance under economic displacement. That notification will come within a certain timeline within the code, and then the city on the back end kind of runs the calculations and figures out whether or not everyone qualifies. So you will be notified when we receive applications for assistance through this economic displacement. And as Dulcie said, we're working really hard to build the program. It's still in its early form days, so there's definitely a lot going into that. It's not in effect until July.
Maureen, there's a question here. As the enforcement manager, you might want to answer, and it's if the rent increase is only emailed, is it proper?
So I already directed that one
Oh,
because it's about a specific notice. I directed them to call our Renting in Seattle hotline because we can review the specific notice. We can review the type of service. Generally speaking, we want to see notices, as Dulcie said, that are delivered personally on paper, hard copy notices, for those notices to be valid. But for us to do anything, engage in any enforcement or do anything around that particular notice, we need to see it. We need to communicate with the owner. Effectively, our code has a requirement, a documentation requirement, where the owner needs to be able to establish when the notice was received. And that's really why giving things in written form on hard copy paper with some proof that it was delivered is a best practice.
right, and makes it so that nobody can argue that they didn't receive the notice, and then we don't have to get involved, which is really your best bet. Keeping us out of your business is the best thing is the best business practice for landlords. Stacy asks if all these rules apply to Section 8 landlords too. Yes, there are some things that in the code in general that are a little bit different. For example, properties that are owned by Seattle Housing Authority are exempted from RIO inspections because they have their own inspection program, for example. And sometimes there are different rules when it comes to subsidized housing, but those are very minor carve-outs. I would say that in general, you can assume that all of the laws, rental regulations apply to all rental housing. Brett Frank Looney is asking, so I raise rent over 10% with 180 notice as I need to know somehow forecast future costs. The resident can't pay, so I am required to pay the city 3 times their rent within 10 days despite my costs. Okay, so I think we just sort of jumped the gun there a little bit. You have to pay within 10 days of when the city pays the tenant. but a whole bunch of stuff has to happen first before that happens. So we have to get all of the income documentation from the tenant, basically. But yes, essentially, if you raise the rent 10% or more, and that causes the tenant to move, you could be looking at paying 3 times approximately the month's rent. And the city isn't going to advance the money, so you'll have to reimburse it to the city within 10 days of the demand letter, basically. There's a question from Vin. What if we have 3 independent individuals renting a house? Would their incomes combine together as one single family for this threshold? The ordinance goes into detail about how the city will be required to consider incomes depending on the relationship between the tenants or the lack of relationship between the tenants. Is there any clarity you want to add to that, Maureen?
We are still working to determine exactly what the calculation is going to look like for housing costs. I will say that housing costs historically in the city have not just been the base rent. They have included periodic and other charges, you know, things such as parking and storage and pet rents or pet fees. So we are looking at the monthly charges that the tenant incurs to live at the property. And we will be developing guidance around what housing costs will be calculated to determine, first of all, how much is a 10% increase, and second of all, does the tenant in fact qualify, and how much money are they going to receive with that 3 times the housing cost calculation. So we are working on all of that as part of program development. So stay tuned. It is a good idea. There's a question in the chat about the landlord listserv. I will drop contact information into the chat for everybody on that. It is a good idea if you are a landlord to join that listserv because as we are developing new policies around these laws that are coming out, that's where you're going to get updated information. Dulcie manages that listserv and is always putting great information out to our landlords as it's available.
Yeah, and I don't just send out communications for the sake of it, because I know that we're inundated with information and emails on a daily basis in this world. So the last thing you need is extraneous stuff from the city. So when I send something out, and generally maybe 4 or 5 times a year, I'll send out a listserv, it's because there's something to know. So just pay attention. If you're interested in being the listserv, I'm sending out information that's useful, valuable, or timely, most importantly. See, I'm just going back to look at the questions again. Okay, so Brett, that's kind of an opinion, not a question, about forcing small housing providers out of the market. I don't know if you were here in the beginning, but I was encouraging people who feel strongly about the impact of these legislations to speak to your elected officials, because unfortunately, we're not the ones. We work for the city. We're just humble civil servants, just trying our best to give people guidance on how to comply. And so it's not satisfactory for you or for us to hear, that this is going to do this, or the whys and the wherefores, because we're not the ones that make those decisions. But having said that, we are very aware of the impact on small landlords. I'm a small landlord myself, so absolutely I understand how scary this time has been for many of us, and how you could really get into a situation of financial hardship. Outside of the COVID-19 moratorium, though, which is exceptional circumstances, a global pandemic, just cause exists. And so if your tenant is not following the rules, is not paying their rent or not paying their rent on time, or you need the property for yourself or your own family, there are 16 good reasons to terminate a tenancy. And so for the most part, fear isn't really something that should come into play for landlords under normal circumstances. You still very much have control over your property and over the tenancies, and you have ways to enforce your rental agreement and to take care of your investment if a tenant needs to be evicted. Brett's questions are helpful because there is no city committee or commission that includes small landlords. SDCI needs to recognize. That's great, but again, that should be direct. If you want to talk to SDCI or city council or the mayor's office, that would be the most effective way to get some results. We are not going to be able to do anything ourselves about that other than give you the best guidance we can on the rules that have been made by the elected officials. So that's what I would say to that. I don't disagree that there needs to be more engagement with small landlords, but that's not something that my job entails, and that's not something that we can really do anything about, not in this small little presentation that we're doing. So let's see here. There's other questions. Let's see. What if we have 3 independent individuals renting a house? Oh yes, we did that already. That's in the process of how we figured that out based on per individual income or household. There's very specific guidance for our directions for that in the actual ordinance, Vin, if you want to go and read it. Let's see. Does the City of Seattle suggest association with Rental Housing Association? There is a lot of different associations for landlords, but this one seems pretty good. Would you recommend? Well, I've used them. I'm a landlord and I've used them for their lease agreements. I would have no hesitation in recommending them. And they're based in Seattle, and they are very aware of all of the intricacies of Seattle rental regulations, and they're up to date on all the changes. So I would have no hesitation in recommending them. I'm mostly familiar with them and WMFA, which focuses a little bit more on larger landlords or larger units, number of units. Okay. Can you speak more to the roommate law then? Can the city use the Rio listserv to notify landlords of new legislation under consideration? We don't discuss proposed legislation. If you are a member of the landlord association, so they do, very much so. They will get right ahead of any potential legislation, and they will communicate with their subscribers and members because they need that support in Olympia when they're lobbying for, more conservative measures or whatever it is. So really your landlord association is the resource to know about upcoming legislation, or just checking in with the different committees that put forward this legislation as well at city council level. You can do that too if you wanted to keep an eye on it. But we really have to sort of wait until they decide what the legislation is going to be, and then they codify it, and then we get to talk about it with the public. And that's just the way it happens.
Yeah, I would suggest on that, if you are interested in up and coming legislation, that you go to City Council's website. You can sign up for email alerts for different committees when things are coming forward. And that's a good way to keep track of things that might be ahead for the landlord-tenant community.
Yeah, I'm sure we'll pass this feedback along, Angie, but not sure how effective that is, because the elected officials are more interested in what their constituents have to say than city employees. It's politics, and we're not involved in the politics of it. That's just not something that's part of our job description, or we can't get involved in it. We basically are here to give access to you to ask questions about rental regulations and do the best we can in helping you understand what those rules are. So I think we're up to date with all the questions. Does anybody else have any other questions about the content we presented on or other rental regulations or questions about your specific issues? This is sort of pre-COVID times. We would have a table and we would be in a physical space and we would be able to engage with you meaningfully face to face and talk about things. But this is what we're left with now with COVID, is that we have to do it this way. But feel free, we have until 3 o'clock. We are available until 3 o'clock to answer any questions that anybody might have.
It looks like we do have a question from Stacy. It came in during the economic displacement conversation, so I'm guessing that's what it's related to. You have to pay just once or continue to pay. If the question is, do you have to pay the relocation assistance for the household or the housing unit, and those things are different under the ordinance, is you make the payment once for whoever's eligible to receive it. There may be more than one group within a single household that is eligible to receive a payment. And I think that gets at the question that Vin may have been, or that Brett may have been asking. Was it Brett or Vin who was asking that? I think Vin was asking that question about how are we calculating the household income. You know, this particular ordinance has very specific regulations and definitions as far as housing units and households within the housing unit. There's a specific definition for family, so I really strongly encourage people, if you haven't read the ordinance, to start there, because it really does define a lot of those things that are going to answer questions around how many times do I have to pay for one housing unit, who's included in a housing unit. All of that is very specifically defined. And I'm going to try to drop a link in the chat, but currently I'm having difficulty accessing the internet while the screen is up, but I will do my best to do that.
And Stacy had just sort of a general group. Are there landlord groups? So yeah, we've been discussing some of those landlord groups. There's the Rental Housing Association of Washington, RHAWA, and there's the Washington Multifamily Association. There are probably some others, but those are the two that I'm most familiar with. We can put links to those in the chat. You should also visit our website, www.seattle.gov/renting in Seattle. That has the most up-to-date information. Now, I will say, disclaimer, that I am still putting updated information on there. So maybe not everything is updated as much as I'd like, but we're in the process of doing that. There has been so many changes in the last 12 months, in the last 3 years, but in the last 12 months, there's been a lot. But that website is designed to help both landlords and tenants. You can go through the landlord portal or the tenant portal, and basically the website is designed as a sort of 360-degree experience of renting from a landlord's perspective, from when you want to list your property, from the moment you decide I have a property to rent, all the way to when you have to return a deposit at the end of a tenancy, and everything in between. And you can look it up that way. You can look up where you are in that process and find the information you need. Also, the Renter's Handbook, which all landlords are required to provide to renters when they first sign a rental agreement. That also is a really good reference tool, and it has an index. So if you can't find where you are in your process of renting, you can just use the index to look something up. Somebody asked yesterday, is there one place you can go where there's just sort of a list of everything, state and city? And I'm not aware of one. I think if you're a small landlord, it really behooves you to be a member of an organization, because they're there to support you. They're there to provide reliable documentation. They're there to inform you of any legislation that might impact you and or your business. And so as a new landlord, I would definitely subscribe to a landlord association and use the helpline. If you have technical questions, if you're going to be doing something or you need to, you need to, you need to do anything basically with your tenancy or your renter, you can get guidance from us. We're a resource as well. So that's what I would say to that question. How do I find out what jurisdiction I'm under so I know which rules to follow? Well, I mean, do you have your property address? Is it in the city of Seattle? If it's not, then it's going to be in some municipality, and so you would call them to see if they have any sort of program. I live in Burien, for example. Burien has its own rental regulations. It doesn't have the enforcement staff or resources that the city of Seattle does, but it does have some of its own rules and regulations. So you just have to make sure that you check. You can look and see where your property is located in the Thomas Guide. That's sort of the old-fashioned way of doing it. I'm sure there's like apps or something that you could know exactly where your property is located. Okay, Diane, I assume that all these rules apply to Section 8 landlords too, or are there additional rules, laws? I didn't hear the answer to this question. Yeah, the answer that I gave to that question was that for the most part, all the rental regulations apply. There are some minor exceptions. I gave the example of Seattle Housing Authority owned properties not being subject to RIO inspections because they have their own inspection program. And there are some other subsidized housing, federal subsidies, and so forth that the rules would be slightly different. But for the most part, you can just assume that it's pretty much the same. It all applies. All the regulations apply. Let's see. Seattle Grassroots Landlord is a helpful informal group. It's on Facebook. Okay. Thank you. I will make note of that. Seattle Grassroots Land People. Seattle Grassroots Land People. Okay. Thanks, Maureen, for putting the links in the chat. May not be relevant, Ryan says, but could you give us a little more insight into Section 8 rental agreements and reward risks for landlords? Is this required for property owners who are adding both an ADU and a DADU? Required by SDCI if you are adding both, I believe. Okay, so you want some insight into Section 8 rental agreements and reward risks for landlords. So back in the olden days, pre-pandemic, when I would do these workshops for landlords in person, I would invite somebody actually from Seattle Housing Authority to talk about the advantages of renting through the Seattle Housing Authority Section 8 program. And so I can sort of reiterate some of what my colleague in Seattle Housing Authority used to say, but we don't work for Seattle Housing Authority. Seattle Housing Authority is this completely separate entity to City of Seattle. I know that's not very clear to most people, but completely different organizations. You know, the thing I would say about renting to folks with Section 8 housing vouchers is your rent is guaranteed. I mean, the portion that Section 8 is paying, you will receive without interruption. You have a third party in this relationship with your tenant. So if the tenant is causing issues, you can talk to their caseworker, and it's in everybody's best interest, and it's definitely an incentive for a Section 8 voucher holder to stay in good standing, because if you lose your voucher, and you can lose it if you are evicted, or you know, if you do something that's contrary to the requirements, you can lose your voucher. And for some people, that would mean homelessness. So I would say that renting to Section 8 voucher holders has a lot of advantages. I do hear sometimes at workshops landlords who might make disparaging comments about people who use housing choice vouchers, but I can tell you from 12 years of enforcement that bad tenants come in all shapes and sizes, and they certainly aren't more prevalent in the communities that use vouchers than they're not. So that's my personal experience. Do you have anything to add to that, Maureen?
Yeah, I would add two things. One is just a reminder that in the city of Seattle and in the state of Washington, that with limited exception, you can't discriminate against renting to someone because they are using a Section 8 voucher. It's called source of income discrimination. So that's actually illegal both in Seattle and the entire state of Washington. And there is also a fund that's managed by the Commerce Department. It's called the Landlord Mitigation Fund. It's been in effect for a couple of years. Now you're probably more familiar with it because they're involved in the COVID relief. But when that mitigation fund was first formed, it was designed to be kind of a reassurance for owners who were bringing in Section 8 tenants who were concerned that if damage was done to the property, that the tenant would not be able to compensate financially for those damages. So it's basically a reimbursement program through the State Department of Commerce, where you can submit a claim if you've had a low-income Section 8 tenant and there was damage caused to the property. So just those two additions to all the information Dulcie provided.
Yeah, and I would say very important to remember that Section 8 voucher holders are a protected class. There are several protected classes, and we're all members of more than one protected class. But certainly, it is completely illegal to not rent to somebody because they have a voucher. I guess I was assuming from your question that you were considering actually enrolling or becoming part of the Housing Authority's Section 8 program, where you can actually go in and be part of the program versus waiting for a Section 8 tenant to come and try and rent from you.
Can I just to clarify that a little bit?
Yes.
So what I was actually asking, if as a property developer you're adding or you propose to add a DADU and an ADU to an existing single family lot, I believe the requirement is that one of the units has to be service to low-income renters or affordable rental housing programs. I'm not sure if it says Section 8 specifically. That's what I understood it to mean. And so that's the context of it. It's not that I'm discriminating against Section 8 or don't want to rent to Section 8. It's more that I'm in a high-income neighborhood as a landlord renter. But I would love to have that opportunity. I just am not sure on the clarification if I'm adding 2 units and is the incentive there to add that second unit because I do or don't want to rent to a lower income group or a Section 8 group. Make sense?
Right. So first of all, the folks who deal with permits for accessory dwelling units are not us. Those are our colleagues. They're probably in another room at this home fair. So you would need to talk to them about any permitting requirements for ADUs or DADUs. I don't know that there's a requirement for there to be a low-income element if you're building structures. I haven't heard of anything like that. But again, you'll need to talk to somebody in permitting. We don't do that.
Thank you.
Sorry, I can't give you a better answer than that.
That's okay. Thank you.
Hey, Dulcie, you're muted.
Sorry about that. If somebody wants to hop on the microphone to ask a question, please feel free, but just put your hand up so that we don't have people talking over each other. Some people like to type.
Just on the phone. Mobile home parks, does that apply to the Section 8 requirement to not discriminate when someone's actually needing to buy a home to live in the park?
It's illegal to discriminate against housing choice vouchers in all kinds of housing. Yeah.
Hey, Dulcie, on that DADU accessory dwelling unit question, it does look like there was a bill, Council Bill 119544, that was passed that relates to green housing and also to affordable housing development. I'll drop the bill number in the chat for the question that was asked about that, even though it's a little bit outside the scope of our coverage here today.
Thanks, Maureen. That's very helpful. So, yeah. So again, our permitting colleagues will be the ones to ask. I'm not familiar with that bill. I had not heard of it, I don't think. So, I mean, I know that the city is very invested in increasing density within Seattle neighborhoods and making Seattle affordable, and restrictions have been lifted on ADUs and DADUs, a lot of restrictions, like requiring the owner to live on the property, for example, is not necessarily required anymore. So I know that they're definitely trying to create policy to encourage density, increased density, and a more equitable housing for everybody. So for example, you live, you mentioned, Ryan, that you have a high rent neighborhood. Well, you know, along with that comes the best fresh food and the best access to green spaces and the best, you know, access to services and resources. And so people who don't make that much income should have access to that too. So I would applaud any efforts to provide anything that's considered affordable housing in Seattle these days, because there's definitely not enough of it. We haven't talked about fair housing in this presentation. Fair housing is a big component of landlord education that I usually manage with my colleagues from the Office of Housing, or excuse me, the Office of Civil Rights. The Office for Civil Rights are the agency that enforce fair housing laws in Seattle. And so fair housing laws are based on protected classes. So like we said, discrimination against somebody who has a Section 8 voucher, or for their, based on their nationality or their age or their parental status or their religious belief. I mean, there's a bunch of them that kind of cover the range. But fair housing laws are definitely something that landlords need to be aware of, and they are woven into the Renting in Seattle website information. So you don't have to go to different places. What's being required of you from the beginning of the process to the end of the process, both as a landlord and a tenant, are presented on the website. So it's a very good resource if you get used to using it. Let me see, I'm just checking the chat. Is there a place to order a renter's handbook, or do we need to print this out and or provide a link? So unfortunately, we just about launched the handbook sort of in the midst of the pandemic, and we didn't have a distribution source for it. Seattle Municipal Tower, where we all used to work, and none of us are there now, we would have copies that would be available to the public. But we just don't have a reliable distribution source right now because of the pandemic, because of staffing situations. We did supply a bunch to the Rental Housing Association just sort of as a introductory, sort of free introductory promotion, because they do cost, these handbooks do cost, and the city does subsidize the cost of them, but there is a cost to them. And so Rental Housing Association did provide them to some of their members and charged a small fee, I think, for handling and shipping. But the 2022 version is almost done because I've had to update the 2021 version. The version that's on our www.seattle.gov Renting in Seattle website right now is the 2021 version. And I will send out an announcement through the listserv when the 2022 version is published. It'll also be translated into all the top tier and second tier languages. But that is also a really good resource, even for landlords to just read through and just have for their own reference. We are working on getting a more formal distribution line in the works, trying to set something up with RHA and maybe some other organizations. But for now, you can either, yes, I mean, for now, the choice is to basically print it off of the link on the website. We haven't printed the 2022 versions yet, so. Can you raise Section 8 rents, or does voucher raise with inflation? So we don't work for Seattle Housing Authority. So any questions that we might discuss or answer on housing choice vouchers, it's very high level. There's nothing to prevent a landlord from raising rent on a tenant with a housing choice voucher, as long as the market supports that rent increase. And Seattle Housing Authority has ways of knowing what the market rate is and so forth. So in terms of the rules that we enforce, as long as you give 180 days notice, and as long as you communicate it to the Seattle Housing Authority as well, because when you do have a tenant with a housing choice voucher, it is a triangular relationship. It's not just landlord-tenant, it's landlord-tenant and housing authority caseworker. And so anything that you send to the tenant has to be sent to the caseworker as well. So that's what I would say is the response to that about raising rent. Let's see. What else here?
I have a quick question.
Maureen just posted a link again to the ordinance, the economic displacement relocation assistance ordinance, which again doesn't go into effect until July. But we had a lot of questions, specific questions about sort of the details. So if you want to go and read the code, there's the link. And then somebody said they had a question.
Yes, if you want to, in advance, rent for just a specific amount of time, let's say 30 days or 45 days, does this 180, does all this apply if you premeditate that you just want to rent for a shorter time, let's say 30 days to 4 to 6 weeks or something, and then you need your space back?
So if you are getting your space back in 30 days or 60 days, the expectation would be that you would not be doing an additional rent increase, right? So the 180-day notice of rent increase wouldn't be required because the expectation is the tenant would be moving out at the end of the term. The challenge you're going to run into is the right of first refusal, because essentially that requires that any expiring term lease in the city of Seattle be given an offer of renewal unless there is good cause under one of those 16 reasons to not renew that lease agreement. So you want to be careful when you're drafting that rental agreement. Definitely talk to an attorney about how to draft that in a way that will enable you to do what you're looking to do, which is have a short-term tenant and then have them leave at the end of that term. Just some clarification for the people that are participating here. We do enforcement, we do technical assistance on the code. We can direct you to the applicable part of the code, but my group cannot give legal advice. And I know that that's something that comes up relatively frequently in the calls that we're handling. Particularly now, it's important with overlapping city and state laws that you definitely talk to someone when you're dealing with notices, when you're dealing with lease drafting in particular, to make sure that all of those new laws are taken into account as you're doing it, so that on the back end, you don't get surprised and have a tenant that you can't have move.
Yeah, I mean, we made the point earlier that it used to be that landlords could write terminating leases, and the lease would be the thing that displaced the tenant. So, you know, I want to rent to Maureen. I only want to rent to her for 1 year. And so I create this contract that says at the end of the year, you need to move out and give me back my property. Well, now the law says that I have to offer Maureen 60 to 90 days before this year expires. I have to offer her a reasonable renewal offer. So I can no longer write a lease that says it ends and you have no rights to stay here afterwards. So, I mean, that's really the bottom line. There were lots of questions yesterday at yesterday's session about Airbnb. And if the rules apply to Airbnbs. And while really on any particular situation, we need specifics to be able to determine whether this code applies or that code applies. In general, Airbnbs are not considered residential rentals because they're short stay. But if you rent to somebody, if you rent the same unit to somebody for 30 consecutive days or longer, then that person may be subject to renter protections. Because
how many days was it? Did you say 60 days or 30?
30 consecutive days or more. It can go from being the lodging tax, hotel sort of type, to being an actual residential tenancy where this person now has all of the protections that the Seattle's codes offer. So you have to be careful. Maureen always comes back to the essential piece of golden advice, which is talk to an attorney, talk to a landlord tenant specialist attorney in Seattle, or you can start with your association, and they often work with attorneys that they can give you direct referrals to, but always get legal advice. And, you know, we can give you guidance on Seattle laws. We can even give you some guidance on state laws. We can tell you where to look and how to look it up, but we can't give you legal advice. And we don't do that. We just basically explain the code and how to stay on the right side of it. And that's our function. And to try and be as helpful as possible too, of course. That's our main reason for being. Stacy's asking a question about screening. So in Seattle, it's illegal to do criminal background checks now, unless you are an owner occupant renting. So that means that unless you're a landlord who lives on the same property where you rent to somebody, you cannot do a criminal background check on somebody. You can check to see if they're on the sex offender registry. But if, for example, they are, that still is not a definitive reason to turn them down for rental housing. You have to have a business related reason for declining to rent to them that's directly linked to the kind of offense that they've committed. You have to be able to tie the two things together to be able to say no. And again, that's the Office of Housing that enforces these particular protections. You can screen for tenant history and rent history and employment history, all of those things, but not criminal background checks anymore.
Just a clarification on that, it's Seattle Office of Civil Rights that handles enforcement for the screening protections.
Did I say Seattle Office of Housing? Yeah. Sorry about that. Seattle Office for Civil Rights. Seattle Office of Housing does very little in terms of working directly with housing providers and so forth. I mean, they manage properties and stuff, but in terms of enforcement or policies or, you know, any of the things that directly sort of impact landlords and tenants on a daily basis, that's mainly SDCI and Seattle Office for Civil Rights. We're the ones that enforce tenant protections, rental housing protections. Where can we get a copy of the recording of this after? All technical questions shall be directed to Maureen because I am a Luddite and not.
I dropped the link in the chat.
So, thank you, John, for saying that there's a lot of great info. We do want to be useful. We want to make this time meaningful. Maureen posted about the day due A-dues, so you can look up that information. Does the city or SDCI track metrics of lost rental units over time and with correlation to new legislations? I can't remember. I know that, for example, there is, and this is actually, funnily enough, a regulation that is housed within the Office of Housing, that if you have a building with 2 or more units and you're going to sell it, and one of the units, at least one of the units is considered an affordable unit, you are required to give the city notice of your intent to sell. And the reason why that was built into this ordinance is because the Office of Housing will then let a bunch of housing providers, generally nonprofits, know that there's this property that's going up for sale in case they want to make an offer on it to try and preserve affordable housing. That doesn't mean the person has to sell to this interested agency. That the landlord can sell to whoever they want to, but they do have to give notice. So that's an example of one where we're trying to track something. I don't think we have a way of being able to track the sale of rental units in response directly or in correlation directly to legislation. I don't think we have a way of doing that, and it's certainly not a reliable way. I mean, anecdotally, we're being told all the time, oh, I'm not doing this anymore. There's too many rules. There's too much regulations. The city is making it impossible. We hear that a lot, but we can't tie that to any specific reliable data. So we don't know. I'm sorry. That's the answer. There might be an audit. There might be some audit being done, but I don't think it's to do with that particular thing. I'm not quite sure. On the City of Newcastle website, there are no listed rental rules. Does that mean I follow the state rules? Yeah, you'd have to follow the state rules. And then I would also just call the City of Newcastle because they may have a housing inspector. They may have some regulations, but they probably don't, have a whole staff or, a robust enforcement program like the City of Seattle does. But yes, state rules apply to everybody, and then municipalities have their own level of laws that come under the umbrella of the state laws, but all the state laws apply across the state to everywhere.
I don't see.
Sorry, go ahead.
Sorry, go back to the previous question really quick about tracking lost rental units. I was thinking with respect to registration of the rental units, how since 2014, all rental units need to be registered with the City of Seattle. And I was wondering, with that data, you would know single family versus condo apartments, so on and so forth. It would be interesting to see.
Maybe not. Well, maybe not, because just because, let's just say I registered, like I have a condo, so obviously it's registered. If I sold my condo tomorrow, I wouldn't let the city know until they sent me a reminder that I needed to register again. So that could be 2 years because I just actually re-registered it. So it could be 2 years before I get another reminder that I need to register. So I don't know that it would be my first priority to call the city and say, take me off the registration. In my experience, most people don't. They usually just call if they've gotten rid of the property or something like that. They usually just call once they get a nudge to re-register, and then they just say, you know, I've sold the property, and then we confirm it and we take it off the registry. But I mean, I guess there's some data to draw from that, and it's available to the public. Everything that we do, all the information, it's all subject to public disclosure. So I'm sure there's some data you can pull from that, but I'm not sure if you're going to be able to get a really solid correlation between the timing of when the legislation got passed to the timing of when properties, you know, reduced, rental properties reduced. Does that make sense?
Yeah, thank you. It does. Appreciate that point. I was just thinking more from the city perspective, not so much from the landlord or myself, in that if we dig into the root of the problem with all these registration and laws and rules, it's really about promoting affordable housing, right? And I think the one part of the affordable housing issue is rental. And if there's a trend, particularly a steep trend in, you know, loss in rental space, that could create more of a problem with the, you know, affordable renting housing. So that was just
Absolutely.
thinking.
Absolutely. And I mean, as a small landlord myself, I do share my perspective with my colleagues and with the department. It was easier to do that back when we all worked in the same office and had in-person meetings, and, you know, information would be exchanged sort of informally and formally. But yeah, I mean, I do believe that the smaller landlords offer affordable housing quite often, because they're not always just about making every last dime out of the property like corporations tend to be about. So they tend to work with their tenants more. If their tenants are struggling, they can be a bit more understanding. They can work with them. They're not excessively raising rent in general if they're happy with the tenant. That's a big part of, you know, their satisfaction. So yes, I share that perspective all the time. But again, a lot of this is politics, and as much as we are subject matter experts in the field, and as much as we talk to folks on a daily basis, we don't have any say in the politics. When we're asked our opinion, we give it, but we don't control the politics at all. We're very separate from that. And so I know that that's difficult for people because we're the city. And so anything that you have to say to the city, you can say to us, and you can. I just don't know how useful it is when it should be something that you either do through your landlord association, where there's power in numbers, or you do it personally by visiting or talking to your elected officials.
What kind of properties need to be registered? Does it include your residential single-family house? Does it include roommates? Does everything have to be registered now?
Yes, you have to register your single-family house.
I apologize for any background noise, but there is an exception on rental registration for owner-occupied single-family homes. That's currently the only exception on rental inspection registration.
Sorry about that. Vin asked if we have a list of resources for reputable or knowledgeable attorneys for landlords. I mean, the reputable ones are pretty well known. I mean, we can't really recommend individual attorneys, but we would definitely direct you to the landlord associations, because they use really good lawyers to prepare their documents and paperwork. Or you could call the King County Bar Association and get a referral through them. But really, you just want to focus on people who are landlord tenant specialists, and not somebody who does it sort of a little bit on the side, but mainly practices other kind of areas of the law. You really want somebody who's very knowledgeable and up to date, especially because the last 3 years have been seismic in terms of the changes and the amount, the sheer volume of new legislation, both at the state and city level.
It looks like there's another question in the chat about eviction. Can you evict for illegal activity performed on the property, like if you suspect they are selling drugs?
That's all yours, Maureen. Go for it.
Okay, I have fire engines in the back of me, so hopefully you cannot hear that. But okay, illegal activity. Currently, we are in an eviction moratorium that is in place through February 14th. So that only allows for evictions where there is an imminent threat to health and safety. Now, whether or not drug activity on the property constitutes an imminent threat to health and safety, that's not a call for SDCI to make. That's a call for you to get advice from your lawyer, and ultimately, if you take that forward to an eviction proceeding for a court to decide whether or not that would constitute an imminent threat. However, I will say that when we are recording notices that need to be recorded under the code, under just cause for criminal activity and drug-related criminal activity, we are going to look for either a police report or an incident number or something in that notice for criminal activity that basically provides some substantive fact supporting the allegation of criminal activity. It can't just be, I think they're doing drugs. You're not going to get far with that with SDCI. You're definitely not going to get far with that in court.
If you're trying to evict somebody on a 3-day notice, there'll be a high burden of proof for you to meet in court before somebody's going to say, yeah, okay, put that person out. So you really, well, I don't know about lately, but traditionally, folks will have a police report, or there'll be an arrest that has happened, or there'll be some real hard evidence that it's more than just a suspicion, in order for you to rely on a 3-day quit notice. I saw here that somebody asked about income source and employment history. So employment history is not a protected class, but source of income is. And Maureen did supply the link to Office for Civil Rights website where you can look up the list of protected classes, but you can't decide based on somebody's source of income whether you'll rent to them or not. So if they don't get, if their income is not from employment, for example, that is not a reason for you to be able to I'm here, sweetie. I'm sorry, my 3-year-old just got up from her nap, so we're right at the end here. But yeah, so if somebody makes income that's not from employment, you can't use that as a reason to not rent to them. As long as the income to rent ratio, so if you have, for example, a 3-to-1 rent ratio, as long as the tenant's portion of the rent can meet that ratio, either because they get unemployment or alimony or retirement or disability, whatever their source of income is. As long as they can meet whatever ratio, if you have one in place, then you can't discriminate against their source of income. Employment history is not a protected class. So, I mean, I would talk with an attorney, but I think you can have, that's not something that has protection under protected classes. So I think if you were saying, you know, you need to be employed Well, you can't because if you're turning them down because their source of income is protected. So their employment history is related to their source of income. So in that way you can't. But employment itself is not a protected class. I'm not sure about emailing out. I'm not sure about that. I'm not handling the technical parts of this. So, and I just got a text. Yeah, something is happening on Maureen's end, so she's locked out of the presentation at the moment. But I believe that there is a link posted in our chat here that you can access the recording. I'm just communicating with Maureen via cell phone now because she's locked out. So I believe the recording will be accessible. I'm not sure about it being emailed. I'm sorry that I don't know the answer to that. Another question, if they refuse to provide proof of income, can I refuse to rent to the tenant? You need to be careful about what you constitute as proof. I would look at the Seattle Office for Civil Rights. Welcome back, Maureen. I was panicking a little bit because somebody asked, are we emailing the link to everybody, or how do people access the recording of this once the meeting is finished? If you can help people understand that. Yeah.
The video will be posted in the Seattle Home Fairs section of the website. I dropped a link in the chat right before my computer crashed, so hopefully that link did appear. It will take some time to get these videos up because they have to collect them from all the different sessions that happened. And then they will be able to get them posted. So they'll be in a single location for all the different sessions of the home fair that happened over the last 2 days.
I was kind of, when I asked you to explain that, I was in the middle of sort of trying to answer a question from Captain about if they refuse to provide proof of income, can I refuse to rent to the tenant? So yeah, just to reiterate that's a sort of, could be a gray area depending on what your standard of proof is and how the tenant makes income. I mean, sometimes people make income that they don't pay taxes on. I mean, we've had to do income reviews for relocation assistance for people who make their money gambling, or who get paid under the table because they don't have a social security number. So, you know, there's all kinds of income sources. I think it's just depends on the specific case. But if you're in doubt, call the Office for Civil Rights, or you can call Renting in Seattle and we'll send you down to the Office for Civil Rights so that they can tell you whether you're on firm ground or not. Or speak to an attorney. Oh, Diane is asking about the chat. Is the stuff in the chat saved as well so that the links are there and all of the answers are there? Is that all saved as well, Maureen?
I do believe the chats will be posted as well. They create a transcript after each session. So my understanding is that the transcript will be posted along with the video.
All right, well, we have 12 minutes left. If anybody else has any questions or comments, but only nice ones. No, I'm just kidding. But yeah, if anybody else wants to use up the last 12 minutes, any burning questions or anything like that, please feel free to hop on the microphone or type in the chat. Maureen, I will be right back.
See another question. Where can I find the links to the video and the chat log for today and yesterday? Again, everything will be posted on the Seattle Home Fair site. Earlier on in the chat, I believe I posted the link. I did have technical difficulties with my computer. So that link will hopefully be in the transcript produced earlier before I was removed from the meeting. So again, the video and chat logs will be posted on the Seattle Home Fair's webpage. If you just search, the easiest way to find it, SDCI and Home Fair in a Google search, it'll pull up that page for you. You'll also be able to see the agenda for all the different sessions that were hosted yesterday and today. That might be a good place to look for the folks that were asking questions earlier where we redirected to things like permitting. A lot of these sessions were around that as well. So you might be able to find some really helpful information in those other videos. Any other questions?
I'm sure there's stuff on ADUs and DADUs. That's always been a popular topic that people show up to home fairs to ask about. So I know that there was questions today about ADUs and DADUs. There's definitely going to be something in the other sessions related to that for sure.
Since no one's asking the question, maybe I'll ask if that's okay.
Sure, go for it.
Thank you very much for guiding us toward the ordinance. So we're going to read some more on that. But I wonder, since we still got some time here, do you know if this is going back to displacement, right? I'm sorry, where if your income is below the median threshold that you mentioned, landlord's responsible to provide 3 times the rental. So I don't know if the ordinance that you mentioned had gone into all the sort of a possible use cases or different situation. In other words, so let's say you have a unique situation where you have a roommate situation in one household, right? And for example, you have 3 roommates in a situation, and one person of the 2 may, if you treat them as an individual, one may be below the threshold, the other 2 is not. Also, add the layer complication, what if they're not all moving in and moving out at the same time, right? If
Right.
So all those sort of a combined situation. I don't know if the city spells everything out, situation by situation, layer by layer or not, and how does that get worked out?
Yeah, so it's definitely a question that we are dealing with as we're developing policies around how to calculate the different pieces of this legislation, which on the front end, the calculation is what does 10% mean? And on the back end, it's okay, who within this housing unit is entitled to receive assistance based on their household's costs, right? So if you think about it as you have a housing unit, and within that housing unit, you might have multiple households. The way this ordinance looks at households is non-family and family member households. So if you have a group within the housing unit that is a family, and this is just, I'm going to have to speak a little generally because all of the policy isn't developed yet, but if you have a household within that housing unit that's all family members, they would count as one household. We would look at their income and we would look at what portion of the housing costs that household pays toward the total cost for the housing unit. If you have people who are in that household or housing unit that are members of a separate family, they are a separate household. We would calculate their income and then we would figure out how much they pay for their portion toward the housing costs and then do the equation from there on what's 3 times, right? Because the housing costs, if you have a housing unit with roommates, is a fixed cost. The rent is $2,500. Now, how they're dividing that among themselves, the landlord might not know that. So it will really be on the city to collect information on who's paying what towards those household costs and figure out what their costs within their household are and then make the determination on how much they are going to receive in relocation assistance based on the equation that they set forth in the code. So you have to kind of look at it as you have an overarching housing unit, who's in the unit and what is their relationship. If they're family members, and this section of the code does actually define what a family unit is, so we will refer to that definition of family that's directly in the ordinance for figuring out who makes up different households within the housing unit. Did that get to your question, Vin? It's complicated, and we
Yes.
expect that we're going to get a lot of questions. I really do encourage people to call us with questions about this ordinance as it becomes effective. Right now, the answer that you're going to get if you call the line with a question is we are working on developing policy, and everything else is going to be answered in the code that we can provide.
Yes, that was great, Maureen. Thank you so much. It was exactly the framework we wanted to understand. I know the detail will still be worked out. So
Yeah. Thank you. It looks like a few more questions have come in.
I see from Diane, read all the details you described about evictions. At what point would a landlord filing eviction notice go on a renter's record that would prevent being able to rent anywhere else? So I think what you mean is, when does something become a matter of permanent record, public record, that another landlord could potentially access and then deny somebody housing, because eviction records are not a protected class. And basically, once you file the summons and complaint, that's when a permanent record is created. And sometimes we'll see landlords who'll serve unfiled summonses, either because they are looking for the tenants to not respond, and then they'll go for a default eviction, or sometimes we'll see them doing an unfiled, serving an unfiled summons to try and still see if there's a way to avoid going into court. I mean, once it's filed, the damage is sort of done for the tenant at that point. Even though there are ways now to try and get eviction records expunged, it's not easy and it's not straightforward. And eviction records do absolutely are detrimental to people's being able to rent a decent place to live. So that's the basic answer. Once you file that lawsuit in court, that's when that permanent record is created, not the notice, not the 14-day notice. Although if a prospective landlord calls you and says, did you issue any 14-day notices, for example, you could say yes or no. But I think what you're talking about is that permanent record that somebody could just look up the name on the internet and find something, and that would be what that is. Do you want to do the next one, Maureen?
The next one I'm seeing, because my chat is a little off, is do we ever do this topic with focus on renters' questions? This has been interesting, right? The landlord's perspective, but there would be many different questions from renters.
Well, this particular session is for everybody, but in our experience, these events and trainings are not well attended by tenants. And the reason being is that most renters have nothing in common other than that they pay rent. And they generally aren't looking for information until there's some kind of issue. Whereas landlords are business owners and they have an interest in knowing what they're supposed to be doing. And so they gather and attend in much higher numbers than tenants have ever traditionally. But as any tenants here can ask any questions, or anybody can ask any questions and we'll answer them. It's just the burden of knowing what the rules are and being able to provide a contract and provide a proper housing unit is all on the landlord, which is why our PowerPoint might seem skewed a little bit in that way. But absolutely, we're a resource for tenants as well.
Yeah, and I would add to that that we, City of Seattle manages grants that fund organizations that do workshops and rights presentations for tenants. And those organizations often come to us for content, for information. They ask for assistance in those presentations. So we are still engaging with the renter community. It's just tends to be through a partner organization rather than directly from our department.
Yeah, thanks, Maureen. That's really important because we found over the years we would put on trainings specifically for tenants, and we'd have maybe 2 or 3 people show up, whereas 150 landlords will register to a sold-out class within 2 days of us advertising a training. So we knew it wasn't effective to do it that way. So then we looked into basically partnering with community-based organizations and supporting them because they have established relationships in the community, and they have access to the people that need the information, and so we partner with them. That's a more effective way. Also, some of these community-based organizations like B Seattle, for example, are much more mobile and niftier. They can move around. They can hold rental boot camps in coffee shops or in in places that small groups can gather and get really good information. They're a lot more mobile, I guess, which is useful, especially in today's current situation. So let's do a time check. Yeah,
We
it's
are
3:01.
just at
We're
time.
done. Yeah.
I
Thanks,
am
everybody.
I'm going to drop a link in the chat. It's for a survey. Please, if you have a few minutes, take them and fill it out. Give us some feedback, what we did well, what we can do better. We do home fairs every year, so we want to hopefully continue to improve each time we do them. And my hope is that next year we will see your faces in person rather than over this virtual landscape. But thank you everybody for coming today, for your participation, your questions. It was a great conversation. And again, this video along with the chat will be available on our Home Fairs SDCI webpage. Just allow a little bit of time for that to happen.
And I just want to thank Maureen for handling the technical side of things. She's the brave one. I just said I'll do more of the talking. But I just want to thank everybody for their attention and for trying to learn how to do this. It's a big deal, and we really appreciate you. And just please reach out if you need any help. Thanks for coming today.